My name is Lisa Guerra, and I'm a long-term D.C. resident and a staff attorney with the D.C. Employment Justice Center, where I represent and advocate for D.C. workers who are victims of wage theft. Thank you, Committee Chair Brown, for providing this opportunity to testify in favor of the Workplace Fraud Amendment Act. Misclassification of workers is just one of many forms of wage theft. Employers who misclassify workers not only steal wages and overtime pay from employees, but those employers also cheat taxpayers and their governments when they fail to pay workers' compensation and unemployment insurance and other payroll taxes that support safety net programs such as Social Security, Medicare, and other programs funded by state income taxes that are so crucial, especially when unemployment rates are so high. For example, in just 16 months after being created, a New York State Joint Employment Task Force on employee misclassification discovered over $157 million in unreported wages and assessed over $4.8 million in unpaid unemployment taxes, over $1 million in unemployment insurance fraud penalties, and over $12 million in unpaid wages, along with over $1.1 million in workers' compensation fines and penalties. In just one worksite alone last year, the Maryland Department of Labor and Industry Division of UI Fraud discovered over $2.2 million in unreported taxable wages and estimated an overall annual loss of between $15 to $25 million to their unemployment trust fund. Between 2006 and 2008, California's Employment Development Department recovered over $137 million in payroll tax assessments, over $25 million in labor code citations, and over $48 million on employment tax fraud cases. Misclassifying employees is already illegal, but is not a direct violation of any current worker protection law. The Workplace Fraud Amendment Act merely simplifies the test for determining whether a worker is a bona fide independent contractor or an employee and imposes additional penalties for this type of misclassification. In addition to helping D.C. collect lost taxes from employers, the penalties imposed by the Workplace Fraud Amendment Act will be an additional source of revenue for D.C. and will deter employers from this all too common practice. We encourage you to pass this bill with its dedicated Workplace Fraud Fund to assist with enforcement efforts at the agency level. Workers are in desperate need of reliable and efficient help with wage theft, including misclassification. For example, Mr. Hernandez, who will testify today, has been waiting to be paid for work he performed over 8 months ago at a D.C. public school, a project funded by D.C. tax dollars under a contract that mandates that workers like Mr. Hernandez, a tile setter, earn a prevailing wage of at least $25.29 per hour, plus benefits. To date, Mr. Hernandez had only received $4.55 per hour of his work, well below the minimum wage. As this case will illustrate, D.C. workers need an agency that will at least identify the misclassification that has occurred and will correctly assess the proper wages workers should receive. Representing workers with individual claims such as Mr. Hernandez requires resources up front that many private attorneys or nonprofit legal services organizations are unable to provide. In 2009 and 2010, I represented a painter who had been misclassified. This worker had been employed with a development company for 4 years and never received any overtime pay. It took the EJC over 75 hours of work amounting to over $15,000 in attorney's fees to finally reach a settlement of his case originally worth $3,600. Mr. Sanchez's testimony demonstrated how difficult it is to navigate the D.C. court system, particularly that the small value of a claim for unpaid wages makes it difficult for workers to find attorneys willing to represent them. Currently, Mr. Sanchez has not even been able to find and serve the defendant in his matter, so his case can't even begin. Having access to an agency that would effectively utilize its administrative power to locate and subpoena employers will prove invaluable progress toward resolution of his claim. In addition to improving the level of assistance the Office of Wage Hour offers its claimants, it's important to mandate attorney's fees for successful plaintiffs so that at least some workers can obtain adequate representation. The Workplace Fraud Act also ensures exploited workers can recoup the proper wages they have earned by enabling other interested parties to bring forth claims on their behalf, reducing the risk of retaliation on individual claimants. The EJC applauds Council members Brown and Mendelson for introducing this bill to address this form of wage theft in the construction industry. But we also encourage you to address the misclassification of workers in industries beyond construction and ensure that wage theft of all forms is eradicated in D.C. Each year, the EJC Workers' Rights Clinic serves more than 1,200 workers with various employment law claims. Via these clinics, the EJC has seen misclassification of many workers who do not work in construction, including office workers, healthcare workers, and restaurant workers. I represented a restaurant worker who asked his employer to be paid on the books via a W-2 and lost his job as a result. A home health care worker was paid for several months as an independent contractor before being properly classified as an employee without ever being told what was going on. Another restaurant worker, a member of another local worker rights organization, informed them that he was denied unemployment benefits because he had been classified as an independent contractor and paid with a 1099 instead of a W-2 income tax form. So not only do they lose the wages their employers withhold, but workers who have been misclassified discover themselves ineligible for many other benefits that they rightfully earned and sometimes desperately need. Misclassification has so many unwelcome effects on our society. It must be stopped so that unscrupulous employers cease profiting at the expense of workers, honest businesses, taxpayers, and their governments. The EJC encourages you to pass the Workplace Fraud Amendment Act and to continue to monitor and address wage theft overall in D.C. with all of these experiences in mind. We also encourage you to pass the Car Wash Employee Overtime Act and hope that you continue to extend the right to overtime and the improvement of services for all D.C. workers. Thank you very much for the opportunity to speak with you all today.